Question 416. A real estate agent did not mention to a client that the property he was being shown had been built near a major ground fissure, and was subject to frequent earthquakes. The client made an offer on the property, and put down a deposit. If the prospective purchaser then finds out about the earthquake issue, he can A. Ask for the contract offer to be rescinded, B. Report the lack of disclosure to the State Attorney General, C. Ask for a novation of the contract, D. The offer must be honored by the buyer. Correct answer is A. Ask for the contract offer to be rescinded. Real estate agents in California have a legal and ethical duty to disclose all material facts about a property that could affect a buyer's decision to purchase. The proximity to a major ground fissure and the property's history of frequent earthquakes are significant material facts that could substantially impact the property's value, safety, and desirability. The agent's failure to disclose this crucial information constitutes a breach of their duty to the buyer. When a seller or their agent fails to disclose material facts, the buyer has grounds to seek rescission of the contract. Rescission is the unmaking of a contract, returning both parties to their original positions as if the contract had never been formed. The buyer was operating under a lack of full information due to the agent's failure to disclose a material fact. They are not obligated to honor an offer made under such circumstances. In this case, the buyer would likely be entitled to the return of their deposit. Question 417. A deposit on a real property transaction can never belong to A. Broker, B. Seller, C. Buyer, D. None of the above. Correct answer is A. Broker. Earnest money deposits, the deposit on a real property transaction, are considered trust funds. The deposit initially belongs to the buyer. It is their money offered in good faith to secure the purchase. If the buyer has a valid reason to back out of the deal as per the contract terms, the deposit may be returned to them. The deposit will eventually belong to the seller if the sale closes according to the terms of the agreement. It serves as a form of security for the seller. Brokers hold these funds in a trust account on behalf of the buyer and seller, according to the terms of the purchase agreement. The broker acts as a fiduciary, meaning they have a legal and ethical duty to act in the best interests of their clients and to handle trust funds responsibly. The deposit does not belong to the broker personally. Question 418. Which of the following relationships create a fiduciary responsibility? A. Seller's broker to the seller, B. Trustee to his beneficiary, C. Buyer's agent to the buyer, D. All of the above. Correct answer is D. All of the above. A real estate broker acting as a seller's agent has a fiduciary duty to the seller. This means they must act in the seller's best interests, with loyalty, obedience, disclosure, confidentiality, accounting, and reasonable care. They must act in the buyer's best interests, with the same set of fiduciary duties: loyalty, obedience, within legal and ethical bounds, disclosure, confidentiality, accounting, and reasonable care. In a trust, the trustee holds legal title to assets for the benefit of the beneficiary. The trustee has a strict fiduciary duty to manage those assets prudently and in the best interests of the beneficiary, adhering to the terms of the trust. Like a seller's broker to the seller, a real estate agent acting as a buyer's agent has a fiduciary duty to the buyer. Therefore, all the listed relationships involve one party, the fiduciary, having a legal and ethical obligation to act in the best interests of another party, the principal or beneficiary. Question 419. The following statements are true about VA loans, except A. A veteran's VA loan is assumable only by another veteran. B. A veteran's particular guaranteed loan amount is called her entitlement. C. A veteran's guarantee rights are reinstated if he sells the property with the VA loan, then repays the loan in full from the proceeds of the sale. D. VA underwriters rely on the debt-to-income ratio to assess if a veteran meets qualifying standards for a loan. Correct answer is A. A veteran's VA loan is assumable only by another veteran. While VA loans offer significant benefits to eligible veterans, one common misconception is that they are only assumable by other veterans. In reality, the assumption of a VA loan is not restricted solely to those with military service. Non-veterans can also assume an existing VA loan, provided they meet the stringent creditworthiness and income standards set by the Department of Veterans Affairs and the lending institution. This allows a broader pool of potential buyers to consider properties financed with VA loans, potentially making the property more marketable. However, it's crucial to note that when a non-veteran assumes a VA loan, the original veteran's entitlement, which they used to secure the loan, is not reinstated until the loan is fully repaid. Conversely, several other aspects of VA loans are accurately described. The entitlement represents the specific guaranteed loan amount available to a veteran, providing lenders with security and enabling veterans to often purchase homes with no or low down payments. Furthermore, a veteran's entitlement rights can typically be restored if they sell a property financed with a VA loan and fully repay the outstanding balance from the sale proceeds. This allows veterans to utilize the VA loan benefit multiple times throughout their lives. When evaluating a veteran for a home loan, VA underwriters heavily consider the debt-to-income ratio. Alongside this, they calculate the residual income, which is the money remaining after monthly expenses. This comprehensive assessment ensures the veteran can comfortably manage the mortgage's financial obligations. Question 420. A Florida resident who is the owner of property in California dies while vacationing in New York. Where will the property be probated? A. New York. B. California. C. Florida. D. None of the above. Correct answer is B. California. Real estate is generally subject to the probate laws of the state in which it is located. This is known as ancillary probate when the deceased was not a resident of that state. The main probate proceedings for the deceased's estate will likely take place in Florida, where they were a resident. This will handle their personal property and assets located in Florida. Since the deceased owned real estate in California, an ancillary probate proceeding is required in this state. This separate legal process will transfer the property's ownership according to the deceased's will or California's intestacy laws if no will exists. New York is irrelevant as the deceased only died there while on vacation and was not a resident nor owned property there. Therefore, the California property must be probated in California. Question 421. Which of the following is responsible for periodic inspections of an apartment building? A. Tenant. B. Owner. C. Maintenance chief. D. Property manager. Correct answer is D. Property manager. While the owner holds the ultimate responsibility, the property manager is the one typically tasked with the hands-on execution of these periodic inspections. Their role includes 1. Regularly assessing the property, checking for maintenance needs, safety hazards, lease compliance, and overall upkeep. 2. Identifying potential problems early, addressing minor issues before they escalate into costly repairs or tenant complaints. 3. Ensuring compliance, making sure the building adheres to safety regulations and landlord-tenant laws. Therefore, while the owner is ultimately accountable, the property manager is the professional most directly responsible for conducting periodic inspections as part of their management duties. Question 422. When a written instrument signed by a person names someone else to act legally for him, that named person is called an A. Subagent. B. Licensee. C. Attorney in fact. D. Paralegal. Correct answer is C. Attorney in fact. A sub-agent is an agent lawfully appointed by another agent to assist in carrying out the principal's instructions. A licensee is a person who has been granted a license to perform certain acts, such as a real estate licensee. While an agent might be a licensee, the term doesn't specifically describe someone named to act legally for another through a written instrument. A paralegal is a legal professional who assists attorneys but is not licensed to practice law. They do not have the general legal authority to act on behalf of another person in the way an attorney in fact does. This is a person who is authorized to act legally for another person, the principal, through a written document called a power of attorney. The attorney in fact does not need to be a lawyer, an attorney at law. Question 423. If a property seller asked his broker about the religious background of a potential purchaser, the broker, A, should provide the seller with the requested information, as long as he also warns the seller that it cannot be used to discriminate against the buyer, that the information may not be used to discriminate against the buyer. B must refuse to provide the requested information. C should ask the buyer's broker for permission to reveal that information to the seller. D. It is the broker's duty to the seller to reveal all material facts such as the buyer's religion. Correct answer is B. Must refuse to provide the requested information. Both federal and California fair housing laws prohibit discrimination based on religion. Asking about or providing information regarding a potential buyer's religious background is a direct violation of these laws. A broker has a legal and ethical duty to comply with fair housing laws. Providing the seller with this information, even with a warning against discrimination, facilitates a potentially discriminatory action. A buyer's religious background is not considered a material fact in a real estate transaction and has no bearing on their ability to purchase the property. A broker's duty to disclose material facts pertains to the physical condition of the property, the buyer's financial ability, and other factors relevant to the transaction itself. Therefore, the broker must refuse to answer the seller's question and should educate the seller about fair housing laws and the illegality of considering a buyer's religion. Question 424. Which institution originated as a federal agency in 1938 with the purpose of providing a secondary market for FHA-insured loans? A. Freddie Mac. B. Fannie Mae. C. Federal Deposit Insurance Corporation. D. Bureau of Real Estate. Correct answer is B. Fannie Mae. Fannie Mae, initially chartered as the Federal National Mortgage Association, was established by the U.S. Congress during the Great Depression as part of the New Deal. Its primary goal was to stimulate the housing market by creating a liquid secondary market for mortgages, particularly those insured by the Federal Housing Administration, FHA. This allowed lenders to sell their FHA-insured loans, replenish their funds, and issue more mortgages, thereby increasing homeownership and affordable housing options. Question 425. A listing contract establishes a fiduciary relationship between the broker and A. Seller. B. Buyer. C. Seller and buyer. D. Seller, buyer, and broker's agent. Correct answer is A. Seller. A listing contract is an agreement between a seller of real property and a real estate broker. In this contract, the seller hires the broker to find a ready, willing, and able buyer for their property. This contract establishes a fiduciary relationship between the broker, as the agent, and the seller, as the principal. This means the broker owes the seller specific duties of trust, confidence, and good faith, including 1. Loyalty, acting solely in the seller's best interest. 2. Obedience, following the seller's lawful instructions. 3. Disclosure, Informing the seller of all material facts. 4. Confidentiality. Keeping the seller's confidential information private. 5. Accounting. Properly handling any funds belonging to the seller. 6. Reasonable care and diligence. Using their skills and expertise to market the property effectively.